Good afternoon. This is Janine Lewis. I am the Director of Quality Assurance, Client Liaison, and Sports Marketing for Bradford and Barthel. I've been in the work comp industry for many years. Prior to working for Bradford and Barthel 6.5 years ago, I've been Claims Manager and National Director for a number of insurance companies in California. I've been involved in the ADR programs for over 20 years. And in my viewpoint, this is really the only way to go. So if you guys are involved in ADR, I salute you. And for those union contractors and union programs that have not yet been initiated into a carve-out, we can certainly help with that. And we can cover that a little bit later. Michael.
Hi, my name is Michael Peabody, and I'm actually here in Tarzana today. Janine is in Ontario, and Tammy, who did the introductions, up in Sacramento. So we're all over the state of California today for you guys. But I've been working with Bradford and Barthel since 2001. I've been involved in ADR programs for the past 7 years, and I've done a number of different types of programs in ADR, and we'll be talking about several of those different programs as we go along today. It's one of my favorite ways of litigating workers' compensation claims. I find it to be a lot faster, a lot more efficient, and we get a lot more done. So I'm looking forward to talking with you guys about this today, and we look forward to any questions you may have. Janine's going to be starting off today, and I'll be picking up a little bit later today.
What we're going to talk about today is the collectively bargained workers' compensation programs using the alternative dispute resolution process. And the concept of ADR and how it works, the advantages of pre-negotiating litigation variables between labor and management, and we're going to give you some of our anecdotal information or practice tips that we've gone through with our ADR experience. Why is there a work comp system to begin with? Without it, workers would have to resort to tort cases in civil courts, and that takes forever. And as you all know, in civil cases, verdicts are extremely expensive. In workers' comp, employees agree to waive most of their rights to sue the employers if they are provided with prompt income replacement or indemnity benefits, medical benefits, and rehabilitation benefits. In a workers' comp, employers are protected from the tort system by using their insurance policies. Doesn't that make sense? The problem at the Workers' Compensation Appeals Board is cases get bogged down anyway. They're in limbo at the Appeals Board, and it can take months, as you know, to get a hearing. And cases just get continued and continued. Another problem is, who gets to be the doctor? WCAB, you never know. At MPN fights, is there an MPN to litigate? Is the doctor available? Who sets up the appointments? What happens if the applicant's attorney refuses to treat within the MPN? We see that often. Expedited hearings, the judge could rule either way. Again, who gets to be an AME? Who will the applicant attorney agree to? Who will we agree to? Who's the most credible physicians out there is anybody's guess these days. Who does the attorney recommend? Will the doctor even be available? You finally get to trial and the judge continues it because the court is so busy. In the meantime, you continue to pay TTD. The lien risks start accruing even greater than they are. Medical liens are piling up despite your objections. Despite the case being admitted, they refuse to acknowledge the MPN. You run the risk of losing at a lien trial, so you pay a minimum of 10%. How wrong is that? The courts ignore the rules, and cases keep going and going and going. Sometimes you don't even know what the problem will be until you get to the Workers' Compensation Appeals Board hearing, and then the scenarios may even change. The average length of time to adjudicate a claim within the WCAB system is usually 2 to 3 years. There's slow benefit delivery, although there has been some improvement, around 33% post Senate Bill 899 and Senate Bill 863. In 2002, WCRB and the California Workers' Compensation Insurance Bureau reported pure premium rates increased to $2.49 per $100 of payroll. The average length of time to resolve cases again is 2 to 3 years. Ridiculous. Current systems become adversarial with bureaucratic layers that lead to delays in the benefit delivery system. Workers become dissatisfied, increasing litigation. And for a no-fault system that we have in California, 41% of all cases, lost time cases, are litigated, and 86% of those are PD cases. What do you think the employee's response is going to be if they don't get their benefits on time? Call their attorney, litigate. A solution with the workers' compensation ADR programs is all these variables are negotiated up front, even before the case is filed. There's no question about whether there's a valid MPN or proper documentation was provided or who's even in the MPN. You've negotiated all of those options up front, and everybody has stipulated, that's labor and management, has stipulated to these agreements. You've already reached an agreement with the other side on a list of AMEs in various specialties, and that remains to be done. All that remains to be done is to schedule them. When you get to an ADR mediation or arbitration, your case is it. It's the only thing on the docket. No continuance without real cause. Since there's nothing to litigate when it comes to the MPN, lien claimants outside the MPN get dismissed. California laws for collectively bargained groups, that's employers, labor's unions, and employers to develop and implement an alternative dispute resolution program. Since as many variables as possible are negotiated in advance, this leaves the ADR system to focus on what truly matters for that individual case. And that's going to be the injured workers' benefits. In 1993, the California legislation passed the Green Bill for Labor Code 3201.5 that established an exclusive jurisdiction within the ADR venue and court system. This allows you to resolve disputes without litigation and outside a courtroom. In 1993, the legislation only applied to certain building trades, and that was plumbing, steel workers, electricians, cement masons, etc. In 2003, Senate Bill 228 added groups such as the public safety officers, janitors, grocery stores, and jockeys. I've yet to see a jockey program initiated, but it's there. California, Hawaii, Florida, Maryland, Kentucky, Maine, New York, Massachusetts, Minnesota, and Pennsylvania all have full enabling legislation for ADR programs. Some of the states have partial enabling legislation, and it would just take their legislation and votes to further with that into their system. Labor organizations and unions are eligible to create a carve-out if they represent the employees in California as to their wages, hours, and work conditions. For Labor Code 3201.5, again, that's the construction trades, you must have an annual work comp premium of at least $250,000 or a self-insured equivalent. In Labor Code 3201.7, which is the other groups that I mentioned, the janitorial, grocery, etc., those minimum premiums are $50,000 for employers with more than 50 employees, or $500,000 for groups or self-insured equivalent. They also must be part of a safety group that has an annual work comp premium of at least $2 million or self-insured equivalent. ADR is vastly different, and you can really tell that at a claims desk. It's highly participatory. Parties actually speak to one another directly and informally about issues and disputes to promote early resolution. Doesn't that make sense? WCAB provides limited remedies for dispute resolution. In the ADR venues, the parties are free to mold an appropriate remedy to fit the situation, which is sensible and swift. Work comp premiums are traditionally based on payroll. In the construction trades specifically, the workforce is highly skilled and paid much better than non-union. In the collectively bargained workers' compensation ADR programs, you can establish man hours and not just payroll for premium calculations. And this seems to be much more fair for this job class. ADR programs must meet or exceed standards established for traditional or statutory system. In any way, you cannot diminish the injured worker's benefits in any manner. Projected savings for ADR programs are anywhere between 10 and 40% of the traditional expected loss factors. 25% reduction in the average length of the open claim, which does mean your file gets closed much quicker. And I've actually experienced, having managed ADR programs in the past, that you do realize an exceptional savings on this. The litigation track is just so much quicker, and that again is where your expenses really are going to be contained. Employers signatory to the program. Who likes ADR? Employers signatory to the program, reps from the unions and management, carriers, insureds, TPAs. The injured workers love it. I've read satisfactory surveys that were published a couple of years ago, the end of 2014, that indicated there was a 45% satisfaction ratio with injured workers that are within the ADR programs. I haven't seen results like this published in the traditional environment. Workers' compensation judges love it because there's less work for them to do. They just dismiss the case for lack of jurisdiction. Defense attorneys love it. It's much easier for them. It's a totally different venue to litigate claims in, which Michael will address. And applicants' attorneys, once they get it, feel it's faster and more equitable for the injured worker. Who hates ADR? The non-MTN medical providers, the lien claimants, and some of the applicants' attorneys, because there's just no shenanigans that you see in the traditional system. They can't play their games. Every program is different depending on what employers and collective bargaining units have agreed upon. Get to know each ADR program you're working with, because as I said, each program agreement is different. They all have different rules, and there's different time frames. The program covers how claims are filed, how doctors are selected, and how initial AOE/COE issues are addressed. But even if employers and the labor union sign off on the agreements, it must be approved by the administrative director at the Department of Industrial Relations. For non-construction programs, that's Labor Code 3201.7, the unions must actually petition for the administrative director to determine if the parties are even eligible to negotiate a carve-out program. So there's an application that's filed, they submit certain documentations, the AD would review it, and then if they feel that it is an adequate program, then they would endorse it, and then the parties can continue with their negotiating. In order to have a valid carve-out, the program needs to meet some basic qualifications. In construction, ADR agreements, this is an addendum to the master labor agreement that's already in place between the signatory employers and the labor unions. In non-union construction programs, this agreement must be negotiated between, labor and management separately from the master labor and collective bargaining agreement. Once ADR program is approved by the administrative director, a letter of eligibility or letter of recognition will be issued. At that point, the WCAB no longer has jurisdiction. Yippee! The concept is when you set up an ADR system, you're really developing an alternative dispute resolution system that governs disputes between the employees, the employer, the insured, that supplements or replaces all or part of those dispute resolution processes in Division 4 of the Labor Code. So all of the Labor Code truly must be followed, the same rules and regs, except there are the agreements that you will abide by based on the individual program agreement. ADR requirements, you need an agreed list of medical providers, an agreed and limited list of QMEs and AMEs. You also need a joint labor management safety group, a limited duty modified return to work program. And again, nothing in the Labor Code or collective bargaining agreement diminishes the entitlement of the injured worker to benefits. Let's focus on this. Again, nothing in the agreement may diminish the entitlement of an injured worker to benefits. And now I'm going to turn it over to Michael. There will be just a couple of minutes, a couple of seconds delay while I do that transition since Mike's in another office, so just bear with us.
Hi, this is Michael Peabody speaking. One of the amazing things about the ADR program is that pretty much what happens is the labor unions stand in the place of the individual applicant, and they pre-negotiate as many variables as possible with the employer side. So they've already agreed that there is an MPN. They've already agreed on who the AMEs or PQMEs would be in a case. They've agreed on as many elements of a case as possible so that when you're litigating the case, you're focused on the things that make this case different from other cases, which are things such as permanent disability. Sometimes it has to do with what types of medical treatment are necessary, things along those lines. So I'm going to be talking about the parts of an ADR program and sort of how this all comes together and works. When it comes to medical treatment, again, there's an MPN in place, and there's no dispute over whether or not there's a valid MPN. There's no dispute over whether or not MPN documents have been properly noticed on all the parties, and there's no dispute about whether the applicant has to treat within the MPN. The issue has already been resolved, and there's an MPN, then there's absolutely an MPN, and that's all we're going to say about it. This oftentimes drives applicant attorneys crazy when they find out that they have to treat within the MPN and they can't send the applicant out to their favorite physicians for ad nauseum treatment. It also helps when it comes to liens. The other part of an ADR program, or another part, are the benefits. Now, the benefits in the ADR program have to be the same or equivalent to what they would receive in the regular WCAB program. Nothing shall diminish the employee's right to receive these benefits. So there's no decrease in any of the benefits, temporary disability, permanent disability, that type of thing. Although some programs, in an effort to get the labor unions to sign on, have increased permanent disability or temporary disability sometimes by 10%, depending on what they want to do. And those savings are offset by savings in terms of how long these cases take. Another thing that ADR programs have to have are prevention programs such as safety programs, and there's often a joint labor management safety program in place that keeps track of what's going on the floor and how to prevent injuries from happening. That is a state requirement, and it's a major component. Dispute resolution, when there's parties disagree with each other, is run differently in the ADR program than it is in the WCAB. And there are three major components to how to resolve disputes. The first thing is that there is a program representative or an ombudsman who will manage the process of the case. This person is charged with understanding the specifics of an ADR program, and they are the first point of reference to the applicant and the applicant's attorney, as well as to the defense side, as to how the case will proceed. If the applicant is claiming that in an admitted case they're not receiving their benefits on time, they'll make a call to the ombudsman. The ombudsman will then call claims or the defense attorney to find out what is going on and try to resolve the dispute informally. If there's an AOE-COE dispute, then they will set the mediation. Or if there's a dispute over any other issue that they cannot resolve, it goes to mediation. Mediation is essentially a replacement for a status conference or an MSC, except in this case, your case is the only matter on docket. And the mediator is present, typically a retired judge, who will try to help the parties resolve the dispute. And if the parties are able to settle, then they just sign on the settlement right there. One thing I should mention is that because these are scheduled where there's only one case being heard at a time, and sometimes they'll stack a number of cases in a day, but they all have a specific time when the person has to be there. Continuances are not favored. So if you want to go in and have the matter taken off calendar or continue to another date, that's difficult to achieve at one of these ADR mediations. It also means the applicant's attorney has to understand that if they're going to try to put additional evidence on, they're going to have it present there at the mediation. There's not a lot of latitude when it comes to discovery issues and that timeline. And mediations are typically in the contract in terms of how long a time has to elapse, or how soon a mediation needs to be set, and how soon an arbitration needs to be set after the request. If the matter is not resolved, or the issue is not resolved at the mediation, then it proceeds to arbitration. And that is the point where the parties have a trial, and the arbitrator will decide which party is right and which party is wrong. I'm going to go into more detail on how these work in the next few slides. So you have the treatment, the medical treatment. Again, the MPN is in place. There's a lot less delay between selecting an MPN physician in the ADR program as opposed to the WCAB. The ombudsperson will oftentimes set that appointment for the applicant and say, look, it's time for you to go. And it cuts a lot of delay out of the program. Same with the benefits. We've discussed briefly the safety programs, and the idea, again, is to prevent injuries from happening in the first place and to keep track of potential safety hazards. This is one of those types of situations where the labor side and the management side are able to get together to come up with solutions to prevent these problems from happening. I should mention really briefly why it is necessary to have a labor union involved in these negotiations as opposed to individual cases. And that is because the labor union, when they are involved, can collectively bargain on behalf of an injured or on behalf of the employees, and they're able to pre-negotiate as a group what the provisions will be in that contract. It's not done on an individual basis, otherwise it would be the same as at the WCAB, and it would be impossible to pre-negotiate a lot of these things. The dispute resolution process, again, ombudsman or the program representative, mediation, and arbitration. There are several deadlines that exist in the programs that I do want to discuss. One of them is that the ombudsman should try to resolve any dispute within 5 to 10 working days. So that's much faster than at the WCAB, where you have to file for a hearing and then you get a hearing date a couple months out and the judge may or may not make a decision at that point. This cuts down time tremendously by maybe five times faster or 10 times faster than at the WCAB. If a party is not satisfied with the result, they can request mediation in 30 to 60 days. And that's also, again, on the tighter calendar. The parties at a mediation tend to get together for a scheduled time. These can take place at hotel conference rooms or at employers' offices. I've had that happen before, or in neutral locations as well. I've also had them at union halls. And the mediator will work to resolve that dispute. If the mediation is not successful in resolving the problem, then the party that's not happy with it can request arbitration that will take place in 30 to 60 days, depending on the program. Some programs only allow 30 days, some allow 60 days. And an arbitration will take place within 30 days. And the arbitrator has a tight time frame when they need to actually issue their decision. An arbitration decision is much like a finding an award in a traditional workers' compensation case. So one of the neat things about this program is that you have a tight time frame from when you go from a dispute to a resolution. And these can happen much faster than they can at the WCAB. In fact, in the time that you can get a hearing in some of the boards like Los Angeles, you can already have your issue resolved. So who is the ombudsman? An ombudsman is a neutral third party that the labor and management jointly select to sort of oversee the case. They are the first point of contact in helping the case move forward smoothly and efficiently. They oftentimes have to answer a lot of questions on a case and tell the applicant and the applicant's attorney how the procedures are going to take place, because most applicant attorneys aren't familiar with these processes. So they do serve an educational role. You can think of the ombudsman as an information and assistance officer type of thing, where they're not on either side. So if you have an ombudsman in the case, you don't necessarily want to relay confidential information to them, but they can provide a lot of the procedural information that can help a case move forward nicely. They also are in charge of investigating complaints about indemnity benefits. That's when that often occurs, or medical treatment not taking place properly or something. And then they can help resolve any of those types of issues. They'll call both sides up and find out what's going on and try to work out a solution to the problem. And the work that they do is fairly informal. So they may call both sides and say, look, here's what the other side is saying, what's going on here, and they'll actually informally draft some type of document that both sides can agree to, or they may simply do a verbal agreement. It helps things move a lot more smoothly and answers a lot of questions for both sides. And one of their main things is to make sure that in an admitted case, the applicant receives benefits without delay. Strategically, that's often helpful because when applicants feel that the system is not listening to them, they'll oftentimes be more inclined to malinger or to add on additional claims or to try to exacerbate the situation so that they do get attention. So when you have a person who is dedicated to making sure that things move smoothly as the case progresses, they feel that they're being heard and that the case can go forward. And this actually results in the cost savings. Their qualities are that they need to be assertive. They are neutral. They're not on the applicant's side. They're not on the employer's side. They're simply there to make sure that things move along. And a lot of times they will talk directly with the applicant and with the adjuster. They are involved in non-represented cases as well. Now, their position is not to simply try to get more money for the applicant, because that's very rarely what they do. But they do try to where the parties can come up with solutions to the disputes. And they also need to be knowledgeable about the particular ADR program. A lot of ombudsmen will actually work on multiple programs, and they keep files on the different programs, and they keep tabs on how different things are done in different places. And oftentimes they will educate the parties as well as the mediator or the arbitrator as to what the particular provisions of that program are. A mediation is a conference or a hearing where the parties are brought together to try to resolve the case. And sometimes everybody is in the room, including the adjusters and the applicant, the attorney, and sometimes the employers are present in some programs. In other programs, it's simply the program administrator or ombudsman and the representatives for both sides. It varies on the system. But what they do is they will try to evaluate the evidence, perceive what they see as strengths and weaknesses in both sides, and help the parties reach an amicable resolution of the dispute. So again, in some programs, everybody who needs to be there, who's necessary to make a decision, will be there. The applicant, the attorney, employer, claims adjuster, ombudsman, interpreter, mediator, and the mediator can actually sign the settlement agreements. I've had a lot of these cases actually resolve at the time of mediation, and it's often the first mediation on a case. It's very rare for a mediation to be continued to another mediation, simply because one party isn't prepared to go forward. And so one of the things that they do is they demand that both sides have authority for a reasonable sum. Now, in a case where it's denied AOE-COE and you're going to be going to arbitration anyway, then you simply just say the case is denied AOE-COE, and you may make a nominal offer. But if you have a case where you have medical evidence, or you have an AME or PQME or somebody who's been selected to make a medical determination, they're going to be looking for authority so the case can be resolved at that time. One of the things I've noticed in practice is where you have MMI report or a permanent and stationary report from a specialist or the main AME or QME in a case, oftentimes that will be the only report that will be addressed at that time at the mediation. If an applicant gets to a mediation and they all of a sudden want to have additional medical records, the mediator will ask them why they haven't requested that before. And they'll ask the applicant that they're aware that they have a psych problem, or if they have a internal medicine problem or whatever. And they'll actually decipher that right there. And you'll end up with a situation where the applicant's attorney will simply say, look, I just want to resolve based on the report that we already have in front of us, and we'll be done. It's very rare for an applicant attorney to be able to use a mediation as an opportunity to review their own case and try to use that as a springboard for obtaining additional specialties in order to increase PD. Also, oftentimes, before mediation, the ombudsman will have already obtained a consultative rating and circulated it between the parties for objection. So if the applicant's attorney has not objected to the rating at that point, then usually that's the rating that will stand, and the settlement can be based around that. In other words, there is a much more favorable opportunity for defendants in these cases to reach settlements when otherwise you may be looking at another year or two of additional discovery. And this is the other type of mediation where you don't have everybody present. And if in a mediation where you don't have the decision makers present, the adjusters and the people who actually have the money available should be available by telephone and can be reached for authority in an effort to resolve the case.
And again, each program is different, and it will stipulate in the ADR agreements if there's a telephonic mediation or if it's a face-to-face mediation where all the parties need to be present.
Well, that's a very good point, because if you have a program where it requires everybody to be present, then that's how the mediation will take place. There's no variation or agreement to any exceptions to those types of rules in these ADR programs. In some programs, there are just the attorneys, or actually there's no attorney present, and you just have the adjuster and the applicant. And sometimes those cases also resolve right there and then and there. And that's also been a very helpful way of getting cases resolved. So what are some tips for mediation? One of the things is to make sure you have the right people available or present to address the issues. One of my favorite programs actually meets in the corporate headquarters of the company. So the risk management vice president is present and can actually approve authority to resolve cases then and there if it is appropriate, or the trials can take place, and if we need witnesses, they're also readily available. But having people available to do what needs to be done at mediation is a key component to getting cases resolved. Good mediations are high pressure. It's the only case on docket, so you will be asked questions at these mediations sometimes, and you have to answer them right there. But it also presents opportunity for both sides to resolve the case. Oftentimes, applicant attorneys are taken to task for failing to complete discovery ahead of time and are informed at the mediation that their discovery will be cut off. So it's oftentimes a very helpful event. And I've had applicant attorneys actually refuse to attend mediations because they claim that it is not a legitimate venue. They don't understand the labor codes which allow for the carve-out. So I've had cases where the ombudsman will telephone the applicant attorney on a speakerphone in front of the arbitrator or the mediator and inform them that they need to be present. Those can be very interesting situations, and oftentimes it results in in resolutions that happen between that date and the next date of mediation if it needs to be continued. Sometimes an ombudsman will actually impose the cost of the next mediation on the applicant's attorney if they fail to appear. So there's a lot of pressure to get the case done as soon as possible without that need. I found that to be very helpful in seeing a number of the cases. A far higher percentage of cases in ADR resolved at the first hearing as opposed to later on in the case. And there may also be issues where the applicant attorney claims they don't have to treat within the MPN, and they try to present all kinds of additional information along those lines, and it's not successful. The mediator will, or the ombudsman actually, will typically inform them of the reality that the MPN has already been pre-negotiated and they cannot get out of it. So there are a couple things that you want to make sure. Some mediators, as retired judges, can actually, you have to tell them, look, you are a mediator in this case. You're here to try to facilitate settlement. So threatening sanctions isn't going to really be that helpful at this stage in order to bring the parties together. So there are some things that mediators need to understand, and oftentimes the ombudsman will make sure that the mediator or the retired judge understands that ahead of time. Mediators need to be neutral and equitable. They need to be able to communicate strengths and weaknesses of each case to each party. So if you're in a mediation, the mediator may ask you what you want to achieve in a case, and they will ask the other side the same thing. And then they'll use that information to try to convince the other side to come to some type of resolution. Mediators can also hold things in confidence. Like if you tell the mediator, look, I don't want the other side to understand this directly, but here's what we're going for. They can also help to bring about resolutions, and that can sometimes have to do with, if you understand weaknesses in the other side's case that you don't want to really bring out until arbitration. Sometimes you can use that and leverage it to your benefit. And good mediators will evaluate the cases from the perspective of encouraging resolution. Now, since a lot of mediators may be new to the process, you want to make sure that if you do tell them something in confidence, it's clear that they're not supposed to tell the other side that information. The same thing does not apply for ombudsmen. Ombudsmen don't necessarily carry those types of confidences, so you want to be careful with that. And this has to do with part of the willingness to adapt to the ADR program. Now, if there is no resolution at the mediation, the matter will then proceed to arbitration. And this is really a trial. It happens around a table. All of the same parties are there that were present at the mediation, along with witnesses who usually will wait outside. And at an arbitration, you may get less opportunity to try to resolve the case. If you don't resolve at mediation, don't set it for arbitration thinking that you can use the arbitration as a continued mediation. If the dispute is not resolved within the first 15 minutes or so, most arbitrators will actually go on the record and say, look, we're going to proceed with this thing. And then you'll put the trial on, and then if you can resolve between the time that the trial ends and the date of the decision, then you can achieve that. But it's really important to be prepared to go to trial when the arbitration starts. Arbitration briefs are usually required in most of the programs that I've dealt with. Mediation briefs are also encouraged in most cases, and you send them to the arbitrator in advance to explain the positions of each side. This is a way of, it sort of replaces the pretrial conference statement. So you're putting your best arguments in there, you're including what evidence you have, and you put it in the form of a brief so you can sort of tell your story through that. I recommend taking the arbitration or the mediation briefs very seriously and mapping out your strategy in that so that the mediator or the arbitrator can clearly understand what you're trying to get. Typically, applicant attorneys wait until the last minute to write their arbitration brief, and it's very skeletal. If you write a good arbitration brief and you're ready to present those arguments and you have your exhibits and everything to back it up, it really gives you a leg up in actually addressing arbitration in the ADR program. So again, have everything ready to go. And key decision makers should be available or present for last-minute settlement. It also presents a good visual if you have a number of people available to attend these things, because it lets the other side know that you're serious about arbitrating the case, and that whatever opportunity you give them to settle the case at this point is maybe their last best opportunity to settle the case. A lot of applicant attorneys, when they first start doing ADR programs, are somewhat intimidated by the process, and so a show of force can actually work to your advantage. Early in a case, they can be held on AOE, COE issues, and that has to do with whether or not the injury occurred at work, and this applies to denied cases. Arbitrations at an early stage are very helpful in helping flesh out those issues, because if a case is ultimately found to be compensable, you want to make sure that you have medical control as early as possible. And some programs, the parties will select AMEs, an AME from the list. Other ones are chosen by the ombudsman. And in other programs, each party gets their own QME, sort of like the old program. Some of the older ADR programs actually allow you to pick any doctor as your QME. And so applicant attorney will select a typical treater, and then the defense attorney will select somebody else, and the arbitrator will have to decide which one is correct. In arbitration, they will, of course, consider the testimony of the witnesses to a case. And if you have employer witnesses present, make sure you prepare them that this is not an informal situation, that they are under oath, and that they're testifying in front of a court, even though it's informally being said in a conference room, and it may be their own conference room. A court reporter will be present. You want to make sure they don't engage in idle chit-chat with the other side. That's sometimes, it hasn't been too much of an issue, but you want to make sure that you have some type of control on what's said in that room, and that they understand that this is a very serious environment. And you put your witnesses on, they'll put their or they usually put the applicant on first, and then you put your rebuttal witnesses on. If everything gets completed, the arbitrator will, and arbitrations usually are completed that day because there's no other cases, and there's no delay. If you have a trial at the WCA B, for instance, and it's set for 8:30 in the morning, it's very unlikely that you'll get on the record that morning on the first day of trial before 11 o'clock. Then the court will take a break for an hour and a half, come back at 1:30, may get back on the record after they clear any afternoon calendar they have, about 2:15. Then the court reporter takes a break at 3:45, and then you come back at 4:30 and you close the day out. In these types of systems, you may have 6 hours of arbitration, and it will all take place that one day. So don't bank on having an arbitration continued if you don't have all your witnesses and everything ready to go. Preparation is key. Having your briefs ready, having your arguments ready, and having your witnesses ready is essential to doing well at these arbitrations. If you get an unfavorable decision, or the applicant attorney does, they can appeal that to the WCAB, and that goes straight up to the appellate level. It will never be heard by a workers' compensation judge. These cases are dismissed from the WCAB, and you do need to file a petition for dismissal to get that done. Because lien claimants will inevitably file their liens to the WCAB, and they won't understand that they need to have their cases actually addressed in arbitration. So when a claim is filed, one of the first things to do is make sure you file a petition for dismissal really quickly, and you get a walkthrough order that the judge signs off that the WCAB lacks jurisdiction. Then you file and serve that on all parties of record, including lien claimants or potential lien claimants. And there's some things you need to include with your petition for dismissal, such as a copy of the ADR agreement, the letter of eligibility, the memo of understanding, and you can cite various case law that supports the ADR program. Dismissal is important, again, so that the WCAB so that the parties understand the WCAB does not have jurisdiction in this case and that it relies solely in the ADR environment. However, I will say that typically in a case, you'll have lien claimants who filed liens either before or after the dismissal, and after the case in chief resolves and they may have been dismissed, then they'll file a declaration of readiness to proceed as the WCAB and get a hearing on a case that's already been dismissed. My typical approach to that is to write a letter to the lien claimant and to the court advising that the matter was dismissed, and I usually include a copy of the order dismissing. And I advise the court that I will not be appearing at that hearing since they lack jurisdiction. Other attorneys will attend those hearings and tell the court the same thing. You know, it's a matter of how you want to approach that issue. But in either case, the WCAB lacks jurisdiction. My approach is that if they lack jurisdiction, the worst thing that will happen to you is that if you don't show up for the hearing, they'll issue a notice to show cause as to why you weren't there, and you can respond that it was dismissed. I would be extremely surprised if the WCAB would attempt to sanction any defense counsel for not showing up at a dismissed case that was already addressed within the ADR venue. So there are different types of programs, different things that you may see in the ADR. One of them is how they address the MPN. Some people or some programs will rely upon existing MPNs that their TPA may have, and they'll simply adapt it to the ADR program. And other ADR programs will have their own MPNs that are set up. I typically recommend trying to piggyback off an existing MPN list that makes sense, because that way, if there are changes made, you can adjust it appropriately. And this is at the contract level. Another thing is that some use exclusive lists of QMEs or AMEs, and other programs pretty much allow you to pick anybody you want. If you have a program with a jointly selected list of QMEs, oftentimes those are resolved much more quickly, and you have less of the back and forth and need to cross-examine competing physicians and things along those lines. Since the ADR program involves a situation where you will have an MPN in place, applicant's attorney will often object to that MPN doctor's conclusion, and then you would both go out and get your own QMEs. So sometimes it's better to have that pre-negotiated so you don't have to address that later on. Then they may have return to work programs depending on the type of contract. And again, nothing will diminish the applicant's entitlement to temporary disability, permanent disability, medical treatment, or other benefits. With claims administration, it's important to have dedicated claims professionals in a lot of programs, or people who actually understand the program. It's a different type of system, and there are different types of filings that are made and that type of thing. So it's important to have people who understand the particular program that they're going to be working in, and they need to be able to work closely with their attorney for handling that. CBWCP means Collectively Bargained Workers' Compensation Program. Again, it's important to remain non-confrontational or adversarial in these types of programs, because you want people to work within the program and not stretch it out by trying to incorporate additional levels of PD and that type of thing. And sometimes it's recommended to have lower caseloads. You may actually handle fewer cases at a given time, but because cases will close much more quickly, you may be able to process a lot more cases over an extended period of time. And litigation management, when claims does need counsel, you need to make sure that your attorney understands how to handle an ADR case. And I know that we've got a lot of experience in our firm. I've done a number of these cases as well, and it is different from the traditional workers' compensation appeals board, although we do handle a lot of those as well. So
we do have 13 offices throughout California, and in each of our offices we have attorneys that are very versed in the ADR programs. They've spent a lot of time understanding the contracts. In fact, Michael has assisted in drafting a contract for our union. So we do really have the experience in this line, so you can really depend on that as a resource.
Okay, now my favorite part about workers' comp are the liens, because they're really, it's a different type of situation. If you are a lien claimant and you're not within the MPN, you don't get paid. As my law professor used to say, you are SOL, surely out of luck. And in denied cases, there's some split as to how the programs are going to address the issue. That's why, again, I recommend COE be decided as quickly as possible. And you want to make sure that lien claimants and potential lien claimants are informed about the arbitration and settlement. So you have to make sure that you understand who's involved in the case so that they get appropriate notice. After the case is resolved, you send everybody a copy of the settlement, and I will send the lien claimants a copy of the ADR provision that talks about the fact that they need to be in the MPN. And the MPN provision of a lot of contracts actually says specifically that non-MPN providers will not be compensated. The matter will then be set for a lien arbitration at a set date and time. And some programs actually go to mediation and then arbitration. Others go straight to arbitration, where lien claimants are expected to appear and actually litigate their lien. In these types of programs, the lien claimants will get a little bit more time to try to negotiate their liens. But what I usually do is, about 15 minutes into it, if it's a 10 o'clock arbitration, at about 10:15, I will request that the arbitrator go on the record and that notice of intent to be dismissed be issued for all lien claimants who are not currently in the building. And oftentimes it's extremely successful. And if somebody does show up, we will address our lien on a case-by-case basis, relying heavily on the MPN arguments. Excuse me. We do recommend, and one of our ombudspersons does this, that all lien claimants be sent certified letters proving that they got notice that this is going to take place, because nobody ever remembers that a lien conference was set. And then if they do remember, half the time they show up at the WCAB expecting to have a lien conference there. They normally don't show up at the hotel room or the conference center or the corporate headquarters where the arbitration is actually going to take place. And if they're not there, then I request they be dismissed. So the arbitrator then reads the name of each lien claimant, puts it in the record, and says, are they here? And of course nobody's there, so they say, okay, this person's not here, this lien claimant's not here, and they'll be dismissed. And if there are, if the ombudsman actually sent notice, or if you have a claims adjuster present who sent notice, or somebody, we can actually have that person testify and say, under penalty of perjury, that they served notice on these parties and they were not there. Having a certified mail return is very helpful in demonstrating failure to attend. So then you get dismissals, either on the record right there. Arbitrator in a lot of programs will just dismiss it, or they'll send out notice and give them an opportunity to respond. I have one arbitrator who actually will tell the lien claimant, if they say that they miscalendared it or if they have some excuse about not receiving notice, they'll say, well, you can have your own date, but you have to pay the cost of the arbitration, and they'll bill them, a couple $1,000s. So I've never actually had one of their, in my experience, I've had a number of liens dismissed, but nobody has successfully gone for a second arbitration and paid the fee. A couple of years ago, I had a case where it was very contentious. I was looking for the picture I had of a stack of paper. There were 50 liens that were dismissed, or 51 non-MPN providers that were dismissed out of hand. Nobody showed up, and the book value was over $500,000. They simply didn't show up. So the arbitrator said that if they wanted to be heard at a later date, they'd have to bear the cost of the arbitration. So none did, and the case was closed, and our client was saved $500,000. So there are a few different things to be aware of in ADR that are different than traditional litigation. First of all, ADR files aren't subject to the typical WCAB subpoena because the WCAB lacks jurisdiction. So you want to make sure that if you get a subpoena for something, that they subpoena it properly under the ADR program and use an ADR subpoena. Now, this is if it's a contentious issue. Otherwise, if it's simply the applicant attorney asking for something, you can send it to them. But this is something that's there for you. Complicated issues like serious and willful or 132A programs can be handled differently. Some require that they be handled outside the ADR program, and others handle it within the ADR program. Certainly, if you have a WCAB judge who's willing to sign off on a settlement of that type of dispute within the ADR program, I believe that that would be binding. Death claims are not handled in ADR jurisdiction, but they must be held at the WCAB, and there's some case law about that. So if you have a death claim, the WCAB does have jurisdiction.
And the reason for that is that the dependents were not party to the collective bargaining agreement. So they weren't negotiating the benefits, etc. So they were deemed to be handled outside of the venues and back at the WCAB. And I've seen cases where you've had an unfortunate accident and the injured worker has been in the hospital for months and then passes away. You can handle within the ADR the first portion of it, the administrative and any medical benefits, accepting the claim under ADR. Once the injured worker is deceased, the adjudication of the dependency benefits would then go to the WCAB. So it makes it a little bit confusing. Thankfully, there's not a lot of death claims within the ADR environment, but they can be resolved swiftly on that dependency issue.
Okay. And so the basic claims philosophy is, taking care of the injured worker, trying to avoid litigation by simply being nice to people, not letting them abuse the system, and treating them with care and compassion. And the labor unions always are very strong on having a spirit of brotherhood between the workers and understanding how that all works. So ADR is really it's a fun area of law. It's a fun alternative to workers' compensation. I really enjoy it because it allows things to move much more smoothly without a lot of the games that get played at the WCAB. And I hope that if you have the opportunity to have an ADR case that you are able to take advantage of all those benefits. Looking here, it looks like we're pretty much out of time here today. It's about 1 o'clock. I'm available to answer any questions you may have.
Yeah, we do have a few questions, actually.
Oh, you do? Okay.
Okay. So the first question is, can teacher unions seek a carve-out for ADR?
I can take that one. Yes, they can. Any unionized environment can do a collectively bargained agreement. It does take some time. They do need, again, to get agreement with labor and management, draft a contract, etc. And the negotiating process usually takes about a year. But yes, absolutely, teachers' unions can become part of a carve-out. And if anybody's out there that does have a teachers' union that wants to discuss it further, please give Mike or I a call and we can talk to you in detail about that.
We do have experience actually setting up ADR programs from the ground up and negotiating the initial processes between the labor unions and the employers. So whatever level something's at, we can assist with that.
Awesome, thank you. Next question is, some of the ADR programs do not allow utilization review, and the ADR program indicates all treatment recommended must be approved, otherwise you must go to a med legal evaluation dispute. Don't problems arise due to this old way of dealing with this?
Michael, why don't you take that one?
Okay. Well, sometimes you do have those types of issues arise, and it depends on how the ADR program is structured. If you have a program that's structured where they have a system that's analogous to utilization review and the parties agree to that, then that works fairly smoothly. But if they have to go through the typical medical legal resolution process, it can take a little bit more time. And sometimes in those types of cases, you have doctors who are pretty much should be involved in the ADR process and understand the types of time frames we're looking at so that they can schedule appointments much sooner. I've had cases actually where the arbitrator, or actually where the mediator will say, look, you need to have a med legal evaluation on something, and we'll make the appointment right there from the hearing room, and it'll take place very quickly. So those are the types of things you want to try to really lean heavily on the ADR program for getting those appointments much more quickly, or getting supplemental reports that address that type of medical utilization issue much more quickly. And the Ombudsman can also facilitate that type of discussion much more quickly as well. But yeah, there are some hiccups that can arise in that type of situation, and it's just a matter of leveraging your resources so that you can address them efficiently.
Great, thank you. And last question. We have experienced ADR ombudsmen setting the matter for arbitration and not telling defendants what the issues are in order to prepare their brief. What course of action can be taken with that?
Well, in an arbitration, you need to, well, if it's being set for arbitration, first of all, it should have been a mediation first if it is on the case in chief. So you want to make sure that you understand what the applicant attorney was going for. I'm assuming in that situation the applicant attorney requested it. So hopefully there'll be some type of communication from that attorney as to what they're looking for. If they're arbitrating something on the case in chief, then you want to know what they're going to be looking for in terms of a resolution, or what medical reports they're relying on, or what arguments they're intending to make. This is where arbitration briefs come in really handy, but of course you want to see what they're going to argue before you issue your brief. In that type of situation, I recommend getting on the phone and being in contact with your opposing as well as with the Ombudsman and saying, look, what's the deal? And a lot of programs, the Ombudsman will actually try to informally resolve the dispute between the parties, and in doing so, you get an understanding of what the actual dispute is about. And then, when it goes to mediation, you flesh it out verbally between the parties, and at that point, if you're unable to resolve a specific dispute, you go to arbitration. So if you're going to arbitration and you don't know what the dispute is, I would really want to pretty much demand a statement of what that dispute is.
Most of the programs, in most of the programs after mediation, the mediator will issue a statement to all parties indicating what disputes could not be resolved, and then the time frame in which to request arbitration. So you would know at that point in time what outstanding disputes are being brought before the arbitrator.
Yeah, you want to make sure you're going in and you're arguing you're arguing about the same thing the other side's going to argue about. So it's really going to take a lot of footwork if you're in that situation to make sure you understand what the parameters are. And let's say worst case scenario, you end up at arbitration and you still have no idea what's going on. The other side usually is typically required to provide an arbitration brief 20 days in advance. So if they haven't done that, then you may be able to leverage that to your advantage. I would recommend, of course, issue a general arbitration brief that at least addresses what your key pieces of evidence are and the facts are, so that you've got that in there, and then you can argue that the other side didn't properly make their case and that their arbitration brief should be excluded. And then you could actually rely on your arbitration brief in order to set the parameters of the argument. I would recommend in that case writing an arbitration brief that plays off of your strengths so that you can define the issues as you see them, since you don't know what the other side wants to argue about.
Okay, great. Thank you very much, Michael and Janine. We really appreciate you talking to us all today about ADR Advantage.